You're listening to podcasts from the Congressional Internet Caucus Advisory Committee, www.netcaucus.org.
Thank you. My name is Nancy Stoll. I'm a tech reporter at Politico. So thank you for coming today. We are here to talk about the EU-US Privacy Shield. We have two excellent panelists to discuss this. I think it's fair to say that when you think about the negotiation of this deal, these are two people that were in the room hashing out the particulars. So we're thrilled to have them here today to be able to provide that level of insight into this, the negotiation and the deal. So to my right is Andrea Glorioso. Andrea is part of the European Union's delegation to the U.S., and he's a counselor for the digital agenda and information and communications technology. To Andrea's right is Ted Dean, and Ted is Deputy Assistant Secretary at the U.S., one of the Deputy Assistant Secretaries at the U.S. Department of Commerce. So thank you both for coming. So Andrea, we were going to let Ted have the first word in sort of laying the groundwork for what Privacy Shield is, why it was necessary, how we found ourselves to this point. But I think we'll kick that to you now. Just if you can just give some background on sort of how these negotiations came about and how we found ourselves at this point.
Sure, thank you, Nancy. Good afternoon, I guess, everyone. And apologies for the late arrival. The sharing economy is great, but sometimes you get Uber drivers who really have no idea what they're going here. So apologies for that. I think I will start, if you allow me, with a little bit of the ground even before the actual negotiations. I think it's important for people to understand what Privacy Shield is and what it is not. Very briefly, in the European Union, we have legislation for the protection of personal data, and that legislation, to simplify very much, prohibits the transfer of personal data from within the European Union to outside the European Union unless certain conditions are met. There are different ways in which these conditions can be met, and one of these is that the European Union, by a proposal from the European Commission to a procedure that perhaps we will have the chance to talk about a little bit later, finds that either the domestic legislation of the destination country, and for clarity whether this is the US or any other country in the world, or a sectorial arrangement in the destination country meets the standards of adequacy. So it protects the privacy and personal data of European citizens in an adequate manner compared to European legislation. And the safe harbor arrangement, agreement, which is what Privacy Shield is going to replace, was one of these sectorial adequacy findings that the European Union agreed, negotiating with the US and then agreed internally back in 2000. And to the safe harbor arrangement, as many of you know, companies which had self-certified respect of the so-called safe harbor principles in the US could legally receive personal data transfer from the European Union to those companies, and only those companies which had agreed to self-certified compliance with the safe harbor principles, which, by the way, this was a self-certification with an enforcement component, which we should can explain in more detail, but broadly speaking, it was mostly left to the responsibility of the Federal Trade Commission under the Unfair Deceptive Act, Article 5 of the Unfair Deceptive Act. So the FTC, Article 5 of the FTC Act, which relates to unfair deceptive practices. Now, what happened is that already in 2013, the European Commission identified, and this followed, and I say this in air quotes, the European Union does not have an official position on the matter, but following the so-called Snowden regulations, there were significant political pressures from many parts across Europe to suspend the safe harbor arrangement because it was believed, or some claimed, that by the transfer of data to safe harbor, US intelligence agencies and law enforcement agencies were obtaining undue access to the personal data of European citizens. To be absolutely clear, and this is on the record, the European Commission refused to suspend the safe harbor arrangement. But after further analysis and after discussion with our American allies, we decided that there were a number of issues within that safe harbor agreement that warranted further work and strengthening. And this was 2013. And at that point, we initiated negotiations with the US, conversations with the US to understand where we could strengthen the safe harbor arrangement. And then in October 2015, the European Court of Justice, following it's called a reference to the preliminary ruling, but as a consequence of the national case which had been initiated in Ireland, initiated by Maxime Schrems, a European Union and Austrian citizen, the European Court of Justice annulled the safe harbor arrangement. This was October 2015. And at that point, the negotiations between Europe and the US, between the European Commission representing the Union and the Department of Commerce representing the US, I think it's fair to say that at that point the negotiations became a little bit more urgent than they had been until that moment. And the point I'm trying to make is that it's not like in October 2015 we woke up and not that, not me, not a lot of the people, we woke up and we said, oh my God, we need to start from scratch. The negotiations that we concluded in February this year were indeed initiated more than 2 years ago. They were accelerated after the decision of the European Court of Justice to announce the problem. I should also point out that a number of the remarks and the reasons on the basis of which the European Court of Justice announced the 2005 decision were indeed elements that the European Commission had identified as items where the safe harbor arrangement needed to be strengthened. Be it as it may, we accelerated the negotiation, and after a lot of negotiating sessions and discussions and trips and conferences and so on and so forth, on the 2nd of February 2016, we, both of us, both the Department of Commerce and the European Commission, announced a political agreement on the privacy shield as the new safe harbor. The Safe Harbor 2.0, that was the operational name the previous word negotiation. The privacy shield was agreed, and on 29th of February of 2016, the European Commission published, this is all public, published the so-called draft adequacy assessment, where all of you who are interested can see what the draft privacy shield decision contains. I will stop here, although I think that we also had the opportunity to explain that I use the terms draft adequacy assessment because, to be 100% clear, we have reached agreement between the US government and the European Commission on what we believe, we as the executives of the Union, of the European Union and the USA, believe is the right agreement. On our side, we still have some steps to complete in terms of consulting a number of our member states, a number of other entities, and I'm happy to go into more detail at the stage. But again, just to be 100% clear, what we have now is a draft adequacy assessment that it is not yet formal European Union law.
Excellent, thank you. Just before we switch to Ted, if I can ask you, can you give a one-sentence elevator pitch explanation for why a privacy shield is necessary? How do you explain this to the sort of average European Union citizen? One sentence.
Well, I will use 2 sentences if I can answer. The first sentence is that it was necessary because safe harbor was announced by the European Court of Justice. So we didn't have anything like that. So we felt we needed an arrangement. We feel that it's also useful because it does introduce better means of redress for European citizens, and it does introduce better means for European citizens to understand what is happening to their data for those cases in which intelligence and law enforcement agencies in the US needs, as all democratic societies do, need to access the data of European citizens to respond to the privacy shield. And again, this is where the teach and happy to give more details when the elevator finishes its course.
Okay, excellent. Ted, can you talk a little bit about how that process looked from your perspective?
Sure. Thanks first for the opportunity for a chance to meet you all today. First, I agree completely with the summary that Andrea just gave, and the sort of announcement we made on February 2nd, the text we released on February 29th, are really the product of 2 years of very intensive work with the Commission. I think for this audience in particular, it's important. I'm here representing the Department of Commerce, but this obviously cuts across the issues we were discussing, cuts across a number of parts of the administration, so there's a very robust interagency process on our side of the table with Departments of State, Department of Justice, the Office of the Director of National Intelligence, the national security issues, and then also the Federal Trade Commission and actually the Department of Transportation, which is the enforcement backstop for a piece of this agreement. So a lot of work that went into the agreement we reached. I think the one element I'd add to the comments Andrea made, and also your last question about why this is so important, is this is extremely important to privacy, protecting individuals' privacy. It's also extremely important to businesses and the transatlantic digital economy. So just to think back to Safe Harbor program started in 2000. Over the 15 years of its operation, grew to have 4,000 companies certified at the Department of Commerce, over 4,000 companies. So just to, again, maybe in the interest of this audience, that mechanics of how it works. Company certifies to the Department of Commerce that they are complying with privacy principles that we've negotiated and agreed to with the Commission. Those privacy principles aren't necessarily required under U.S. law, so they're not, in and of itself, it's not enforceable that a company would necessarily comply with those principles. But because a company certifies to the Department of Commerce and makes a public representation that they will comply with these principles, that public representation is then enforceable by the Federal Trade Commission. So it's a way, it's a bridge that takes principles that you need to follow to transit for uses and data and bring it into the U.S. legal system in a legally enforceable way. So we needed to find some way to create that bridge. That's number one. Number two, for companies, this is most often associated in sort of press and discussion with the largest internet companies, who are obviously among those companies that move the largest number of people's data. But you can tell by the fact that we have 4,000 plus certified companies that it is all types of companies that are involved, and large number of SMEs. So it's not only the data that might be captured in a web search history or captured in an email or captured in a social network, but very basic business functions. So small company hires 2 people in London. If they want to move their employees' data back to the United States and comply with EU privacy laws, they might certify under Safe Harbor. If you are a company selling product in Europe and have warranty data, you might use Safe Harbor. If you are a pharmaceutical company and have patient data, you might use Safe Harbor. So all types of very basic business functions. And I think when, as Andrea outlined, we worked at this very intensively for 2 years, and we're working, I think, both sides really constructively to get to an agreement, but as many things in government, they take time, and we didn't have a hard deadline, but the Court of Justice decision really gave us was a hard deadline, because at that moment, you had 4,000 plus companies who went from having a valid legal basis for transfers to not having a valid legal basis for transfers, and the prospect of either halting certain types of operations, which we then needed the data to perform those operations, or facing enforcement actions in Europe where they might have been fined or faced orders to stop transferring data. So a lot was at stake. We think the agreement that we reached in February is a really significant achievement for protecting privacy. It's a really significant achievement for providing greater certainty to business, and responds in a very robust way to the Commission's original 13 recommendations from November 2013 when we began our negotiation, but also to the points that the Court of Justice had raised in their case. So, as Andrea outlined, we're in the midst of the approval process. We're working very closely with the Commission and colleagues in Europe to provide additional information, explain what we've done, and make sure folks understand exactly what's there as they do that evaluation as part of the approval process. But we're also conscious that there is, I think everyone expects that there may be a legal challenge in the future, that this might end up back at the Court of Justice. And I think, but I think our conclusion and the conclusion of the Commission, I think you've always said this right, is it meets that standard, and that we will withstand a legal challenge when and if we face one in the future. But
Excellent.
more to talk about.
A quick process question. If the European Court of Justice had not given you a hard deadline, as you mentioned, with their ruling in October, how close were you to a deal?
We were very close. We've been at it for 2 years. I think part of the process at the end of the negotiation was we actually had achieved a lot, covered a lot of the ground we needed to cover, but then we also had thoughtful but also complex court decision, and we had to sit down with, if you look at the package that we released on February 29th, it's over 100 pages, you've got an over 50-page court decision, and we really had to sit down and say, what have we done here that already addresses things that are in the court decision? As Andrea said, there was a lot that was. But there were some other things where we thought, well, we need to go back and look at what more we need to do to make sure that this is a durable agreement that would withstand any future challenge.
Okay, excellent. So you both mentioned that negotiators from the U.S. and EU reached a political consensus and still going through the formal approval process. What does that look like? What more information is being asked for? And if you can handicap the odds of it being approved in the near future.
No, I will not indicate the answer because that's not up to me, and I'm serious. That's now up to the member states, and if you have the players, and I'm going to explain briefly what the process is going to look like. If I may answer before I get into that process, let me just clarify, because I kind of mentioned it in passing, and I want to make sure this is crystal clear. We, of course, completely agree with this government when it comes to safe harbor, privacy shield, safe harbor, not privacy shield. For companies, not only American companies, by the way, also European companies use safe privacy shield. I'm going to keep on saying safe harbor for the 6 months or so, I know that. But the previous safe harbor, when it will become a legally operational privacy shield, is not the only legal basis through which personal data can be transferred from the European Union to the US. There are a number of other options within our legislation that are admittedly more cumbersome and probably more costly for companies to use, but they exist. And I'm saying this because there was a moment, especially when the Court of Justice decision became public, in which people were panicking a little bit, and again, we were very conscious of the seriousness of the decision, and the acceleration of the negotiation is a proof of that. But the war was not coming to an end. There were other options available. Having said that, in terms of the process, as I mentioned on the 29th of February, the European Commission officially presented the draft adequacy decision, which was accompanied by, as Ted mentioned, a substantial number of pages of annexes, including explanation on how certain parts of the privacy shield are going to work, for example, in terms of the alternative dispute resolution system that is now available free of charge for European citizens, of the arbitration procedure, which is proposed as an additional venue redress for European citizens, on how the new ombudsperson, and this I understand is the politically correct way to call which is funny, right? Ombudsman is actually a Swedish term, and I don't believe it's associated with gender, but we're going to call it ombudsperson just to be on the safe side. So we presented on the 29th of February all that package. Now, what's going to happen? The procedure, which is, by the way, a standard procedure to which all draft adequacy decision become formal adequacy decision. This is not specific to the privacy shield. It's not specific to the US. It's a procedure we follow in each and every case. So we need to have the non-binding, to be clear, but very, very important opinion of the Article 29 Working Party, which were all the 28 national data protection, European data protection authorities sit. We need to have the non-binding, but equally very important opinion of the European Data Protection Supervisor, which is the data protection authority with responsibility of the processing of personal data by European Union institutions.
I'm so sorry, can I ask you, because we don't have data protection authorities in sort of that defined body. Can you explain how that functions?
A data protection authority or a privacy authority changes name depending on the member state, but they are independent administrative authorities. They were created under the 1995 directive. They are independent of the national government, and their job is mainly, some of their tasks slightly change from member state to member state, but broadly speaking, they have responsibility to investigate cases of possible non-compliance with privacy rules, enforce on the first stage at the administrative level those rules. The decisions of data protection authorities are always I'm forgetting the English word, they can be appealed. They are always appealable in court, in judicial court, to be crystal clear. They also have a role of advice, most if not all of the protection authorities advise their national governments and their national parliaments, and they advise through the Article 29 Working Party, they advise European Union institutions on data protection related matters. I hope that. Yeah. So we need to get the opinion of the Article 29 Working Party, the opinion of the European Data Protection Supervisor. We need to have the it's so-called comitology consultation process. I see you're already following this lead, so we keep it simple. But basically, we need to go to a committee composed of representatives of the governments in member states. So you will notice the difference. The Article 29 Working Parties, the data protection authorities, those are independent of the national governments. The Article 31 Committee, with members of the European Union, is composed of representatives of national governments, and we need to get either a qualified majority, a supermajority of representatives in that committee in favor of our draft adequacy measure, our draft adequacy proposal, or it's okay if we do not get a qualified majority against. But in any case, we have to pass through that as well. And then, please, whichever in the press in the room quote me correctly on this, because you and I guys, we had some problems in the past, so I want to be crystal clear on this. We technically do not need, according to this procedure, the opinion of the European Parliament, but given the political importance of this issue, we felt, the European Commission, that this deserved the directly elected representatives of European citizens to clearly express an opinion. So we will also wait for an opinion of the European Parliament on this. As you can imagine, this whole process will take a bit of time. We hope, the latest that I'm told from Brussels is that we hope that this whole process can be concluded and touch wood, with no problem, with no objections, can be concluded by the summer, by the beginning of holiday period in Europe. As I said, though, because you asked me on the odds and I guess on the timing, at this point, I feel that we, as the executive union, we have done our job. This is not the responsibility of a number of other parties, frankly speaking, to express their opinion and to take the responsibility on how they want to position themselves in this debate. And once that happens, so when all the process gets through, with no problems, at that point the European Commission will take the formal decision to turn the draft adequacy decision into a formal adequacy decision. And at that point, Privacy Shield will be fully and legally operational, and companies will be able to use that as a legal basis to transfer personal data from the European Union to the US, in addition to the other legal bases, as I mentioned before, which continue to exist. As far as the Commission is concerned, were not impacted by the decision of the European Court of Justice in Shan fully, even though we know very well that there are other parties which have a different opinion. But to be clear, the European Commission believes that those other legal bases continue to be valid and legal.
Okay, excellent. So Ted, how is the US feeling about the chances of approval?
Step back one moment and just say one of the reasons why I think the review is complicated and these folks are weighing in. I'll come to your question about how we sort of handicapping, I guess. It is a complicated agreement, and maybe it's just helpful to spend 1 minute saying what's there, because I think that'll help explain why the European institutions, Parliament, data protection authorities, member states need time to take a good look at it. So the 140 or so pages that were released on February 29th include sort of three main baskets of documents. The first is principles that companies commit to in terms of their handling of data and the protection of privacy. So that this is sort of a update and expansion of the safe harbor principles. And so that was a negotiated text. It's new. There's a number of new changes. There are a number of things where we've done more to enhance the privacy protections related to the notices that go to EU citizens, related to onward transfer when a Privacy Shield company receives data and sends it on to another company, a cloud services company, or someone else. There's new provisions there. So they're looking at that obviously very closely. Then there are commitments from the United States government about how we will implement this. So that's a letter from our secretary and a letter from the undersecretary of the International Trade Administration about how Commerce will implement this. There's a letter from Chairwoman Ramirez outlining the Federal Trade Commission's role as an enforcement backstop. There's a letter from Secretary Kerry describing a ombudsperson mechanism. It's sweet. I'm speaking the original Swedish mechanism, which provides a form of redress for when an EU citizen does have concerns about national security or sales intelligence access. They can go to their appropriate institution, their own government. That institution can come to the Department of State, the Office of Undersecretary Novelli, and she can then, working with Inspector Generals, the Privacy and Civil Liberties Oversight Board, and other independent oversight mechanisms we have related to our intelligence community, provide an answer back that the U.S. law is being complied with in the handling of any data. And so this was a really important element of meeting the court standard and making sure that we had addressed concerns about government access to data. So there's a letter defining that. That's a brand new mechanism that we created. And then finally, there are materials that provide assurance to the European Commission about the safeguards and limitations that we do have in place in the United States related to national security, law enforcement, or public interest access to data. And all of those are, very robust safeguards that do protect privacy, but they're also complicated bodies of law. So the fact that we're in a several-month approval process and EU institutions are taking a very close look at this, we think makes sense. It's the part of the process that we should be in right now. And what we're doing now is working very closely with the Commission and making ourselves available to explain this and then answer questions. And so just last week, for example, I was in Brussels and we met with the Article 29 Working Party, so this group of data protection authorities, and briefed them. We testified before the European Parliament, explaining the work we've done, and we met with representatives from member states. And so that was, a couple of days last week, but we've been here a number of times since the February 2nd announcement of an agreement, and we'll continue to go through this approval process to get all the way through. I think what we've done meets the standard that was set out for us, provides very robust privacy protections, and is really important to business and the transatlantic economy. And I think there's a recognition of all of those things, the privacy protections and the importance in Europe. So we're not, how do I say, leaving anything to chance. We're going to continue to go, we're going to continue to explain, we're going to continue to answer questions. But I think we're also optimistic that we'll see this all the way through to the goal line.
Okay, excellent. So Andrea mentioned that the original safe harbor was tossed out by the European Court of Justice amid post-Edward Snowden concerns about U.S. access to European citizens' personal information, the information being held by some of the bigger U.S. internet companies in particular. Were at issue with that particular case, it was Facebook. Given that under the draft agreement, there are no new concessions about U.S. law. Nothing has changed on the U.S. intelligence gathering side, particularly tied to the crafting of this agreement. There's a letter from the Office of the Director of National Intelligence assuring that U.S. law is adequate for protecting Europeans' data. Is that resonating with the same folks that initially raised concern about how protected their data is from the U.S. government?
Yeah, it's good call, bad call, and setup. No, actually, there are only good calls here because, first of all, I will let Ted speak to this, but I want to say that certainly from our perspective, it would not be entirely correct to say that nothing has changed in the US, because as a matter of fact, there have been significant legislative changes that were not triggered nor requested, to be completely clear, in the context of the safe harbor negotiation, but nonetheless took place. And again, Ted may want to go into more detail, but from our perspective, PPD 28, or the USA Freedom Act, and a number of other changes have been, the Judicial Redress Act, have been extremely positive in terms of the protection of non-Americans, and specifically European citizens, and they're in the same situation. But most importantly, One, now, at the European Commission, we are not in the habit of commenting the decisions of the European Court of Justice. That is the equivalent of your US Supreme Court, is our top court, and we take them as they are, and it's the local area, and we implement what is in there. Having said that, I think that many people seem to have interpreted the decision of the European Court of Justice in the Schrems ruling as if the court was directly commenting on the state of the law in the US. But if you read carefully the decision, what the court, in fact, or the main reasons why the court announced the safe harbor was mostly, I could summarize it as, it was, let's be very clear, it was a slap on the wrist on the European Commission, first of all. We are accustomed, we get from time to time slaps on the wrist, and it's normal. If you don't do, you don't fail, or you don't make mistakes, as we say in Italian. Because, and also the Irish Election Authority, to be clear, which did not investigate stuff that it was supposed to investigate under the existing safe harbor arrangement. But bottom line is, the European Court basically, to simplify very much, told the European Commission, you have not done your due diligence in actually presenting in the safe harbor arrangement that certain safeguards for European citizens were in fact in place. Because let us also be clear, in that kind of procedure, it is not the job of the European Court of Justice to take decisions on the laws of the sovereign, of the third country, the sovereign country, not directly. This is why I think, and again I will let Ted perhaps talk more about it, but I really want people not to underestimate the importance of having an official signed at the highest levels of the US government representation clearly stating that this is our legal system, these are the safeguards in place. This is why third parties, in this particular case the European Union and EU citizens, can feel safe that our access to data for national security and law enforcement reasons, which incidentally happen all the time in Europe as well, happen in all democratic societies. We all have intelligence agencies, we all have, thanks God, I should add, and we all have law enforcement agencies. This representation by the US government was and is extremely important. What was the problem is that until that point, we did not have, or we felt at least on our side, that we did not have a clear political, if I may use the word, as diplomatic as possible, we did not have a clear assumption of political responsibility by the highest level of the US government on the way their system worked. We had a lot of op-eds in the New York Times, we had a lot of public statements, but as a sovereign entity, that was not sufficient for us, in particular following the court ruling, to go ahead. Now, I'm perfectly aware that we are very aware that there are a number of parties out there, including the party that originally started this whole case, which have gone on record saying that they believe that the statements by the US government are completely valueless, they don't have any value, that nothing has changed. We respectfully disagree with that assessment. If we thought that that were the case, we would not have accepted to conclude the political agreement with the US government, because believe me, we know there will be another court case. We are as confident as you can be in these kind of processes that we have a solid package if we will have to go in front of the European Court of Justice, but we have no particular desire as the European Commission to be that one of our decisions is struck down again by the European Court of Justice. So if we have reached this point, it's because obviously we believe that what we have been given or what we have agreed with the US government is quite good, is good enough.
Okay.
I think from our perspective, we very much agree with Andrea's interpretation of the court case. I think it's important to go back and as Andrea said, read the court case. The case makes no findings about the adequacy of U.S. privacy protections. It makes no findings about government access to data. It makes no findings about practices of the National Security Agency or other intelligence agencies here. And so what the court did was say that the European Commission, in evaluating the adequacy of a third country, in this case the United States, should evaluate not only then the safe harbor, now privacy shield arrangement, but also evaluate the broader legal context. And that's an eminently reasonable position. If you took the safe harbor arrangement and Europe were to enter that agreement with a totalitarian country somewhere, the fact that there's a national security exception and a law enforcement exception that protects companies from being put in conflict of laws situations would introduce the risk that the exception would swallow the rule. That in a country without the rule of law, with limitless government access, that exception would swallow the agreement. So what the court called on the commission to do was evaluate the broader legal context. The other reason they made no findings on U.S. intelligence practices or government access is because they had no information or basis on which to make those findings, because the case that was referred to them when it went through their proceedings was from an Irish court case that had originated in 2013, and there, just as the way the legal process evolved, there was no further fact-finding. So that's not a criticism, that's just a fact of the way the legal question was posed and the way it finally reached the court. And so the court wisely refrained from making determinations on something they didn't have a factual basis to make determinations on, and pointed to the commission to do that. We had been already engaged for almost 2 years with the commission, providing information and briefings for a very senior level in Office of the Director of National Intelligence, explaining what we do and what we don't do, and the limitations and safeguards that are in place. And to Andrea's point, I think we obviously believe that the safeguards that were in place in 2013 have been mischaracterized as this evolved, but that we could also point to very significant reforms captured in Presidential Policy Directive 28, captured in the USA Freedom Act and otherwise, that provided the assurance that when the Commission was making this evaluation, they could now say, we've not only looked at Privacy Shield, but having done a full evaluation of the broader legal context, we can say with certainty that we believe that the protections are adequate.
Okay, excellent. So,
Nancy, for me, 1 minute.
yeah, right.
None of us are capable of short answers.
That's great.
This is why the
negotiation is so long.
negotiations.
2 years. I feel that I need to, so obviously there is an agreement, not only between Ted and myself, but between the European Commission and the US government. I do, however, feel the need to point out that the European Commission, and this is enshrined in the draft adequacy decision, which we all hope will become an adequacy decision, reserves the right to assess on a yearly basis how this agreement will actually play out. Now, the US is our first and foremost ally, and when there are statements made by the highest political levels of the administration, we take that at face value, just like the US would take at face value what we tell them. But as we say in Italy, trust but verify, and things change and implementation. Sometimes it's not even, it's not another way to do it, it's just that we think that we have understood each other, but then when we get to the implementation phase, we discover, okay, it's slightly different than what we had thought. Bottom line, and this is one major, at least from our perspective, a major point of the new Privacy Shield, after the assessment, and the assessment will be validated, this yearly review, to which every year a joint group composed of the EOC, Department of Commerce, and the European Commission, plus participation of other protection authorities and intelligence agencies within the decision of how the US government will decide to handle this, will review the situation, and the European Commission reserves the right and the prerogative to suspend, if necessary. We didn't do it in 2013 because we thought at the time that it was not necessary, but we reserved that right under the new Privacy Shield legislation. I want this to be clear. Having said that, we have worked very hard together, and I want to personally thank Ted and Justin and other colleagues who are, I think they'll get the European passport very soon, the other day in Brussels or somewhere, but the help that the US colleagues have given us to explain to sometimes difficult interlocutors, let's be very clear, what's actually the legal situation in the US has been invaluable, and from the delegation we said that we can also explain to US interlocutors how the EU system actually works or doesn't work.
Okay, excellent. So we're going to open up for questions. To give you 1 second, we have questions. Just very quickly, who came up with the name? I've been curious.
It wasn't me.
It was you?
No, it was not.
Oh, it's not. Is it you, Tim?
No.
Okay. Let's see right here in the blue coat. Yeah.
So I'd like to know how this affects privacy reporting requirements for unclassified law enforcement systems, specifically like privacy impact assessment, system of records notices. Will there be an increase in information required to be reported from those? Will there be additional reporting requirements?
Okay. Can everyone hear the question? Okay. And if we have a number of questions, so if we could.
Sean, very quickly, I mean, I think in terms of, you mean in terms of reports on law enforcement or government access that companies may issue?
That maybe there's an exception for law enforcement information brought across from the EU to the US.
So actually, Privacy Shield only relates to data that moves from one company to another. There are other agreements and other ways that data is transferred between governments, but this only relates to a company that moves data, a European company or a company based in Europe that moves data to a company based here, that flow of data. And then the government access we're speaking about is, once it's here, is there a situation in which there may be national security, law enforcement, or public interest access to data here, but it doesn't change anything related to government-to-government sharing of information. And then in terms of companies reporting of government access, that's define what's possible under the USA Freedom Act, and that nothing in this agreement changes what's possible in that regard.
Okay, excellent. We got no women raising their hands. Let's go over here.
A question for Andrea. We're having our own debates about privacy versus security in the U.S. Are European police and intelligence services satisfied with their access to consumer data in Europe under the present arrangement, or is there any possibility of that being reviewed in the wake of recent terrorist attacks?
To be clear, you should ask that to law enforcement agencies, because I cannot speak on behalf of law enforcement agencies. B, that doesn't really concern the privacy shield, to be clear, because for the reasons that on a broader context, there is certainly an ongoing discussion in Europe, within the Union, in terms of intelligence and information sharing. I am not aware, but if you wish, I will check with my colleagues who work at Europol, that at the national level, law enforcement agencies have raised particular concerns in terms of access to data within the European territory. But this is separated and independent from the privacy shield discussions. And if you want a clear answer, you should ask, and with respect, you should ask the law enforcement agencies, because they have a better grip on what they do or they do not need. And they do not necessarily share their feelings with the European Commission. So.
Can I say, speaking on behalf of all of Europe, are folks in Europe tracking the iPhone encryption case that we have going on here?
I certainly am, and a few other colleagues are. I can tell you that yes, obviously it's of great interest in Europe as well, because it's no mystery that we have similar debates in Europe as well in terms of what is the level of access to data, whether it's encrypted or not, that law enforcement agencies should have. So yes, we are following that.
Okay, excellent, thank you. Here in the orange shirt, yeah.
Andrea, earlier you mentioned that there was a yearly review process that will be taking place to see whether or not changes have to occur or adjustments to the current agreement. Does that mean, from a startup perspective, an individual who has a startup providing services both in the U.S. and in Europe, that they're going to have to continuously monitor and make changes to adapt to whatever whatever your enhancements are? Because it could be catastrophic from a financial standpoint. We're kind of taking our
Looks like that might be a Ted question.
Let me just talk about it.
Maybe, I think from our perspective, the annual review is a very good thing, and lessens the risk of what you're speaking of rather than increases it. And the reason is, I think from our perspective, if we had an annual review for the 13 years of Safe Harbor's operation, and you imagine, again, an agreement negotiated in the late 90s, all the things that had changed in terms of data flows, business models, number of companies that were involved. Clearly, new issues were developing over that time, and candidly, we were not in regular enough communication with the Commission or with the European Data Protection Authorities to address those issues as they come up. So I think from our perspective, much of what we will tackle in an annual review will be the operational issues of how we implement this. What is a new issue that's arisen that may have, pose a novel challenge for a enforcement agency in Europe or for the FTC? Again, from our perspective, the more we're having those types of conversations and dealing things in the operation of the framework as we go, the less likely we're going to end up with a criticism which says you got to tear up the agreement, go back to the negotiating table. And so, and we fully accept this, as Andrea pointed out, we recognize that there's criticism in Europe about what does this mean and how seriously the U.S. takes these commitments. And I think just as a political reality, it's important that there is an opportunity for folks to look and see that we are, in fact, following through on our promises. Not to suggest that we're going to have to change our promises every year, but simply that critics in Europe or elsewhere, there's a regular opportunity to look and make sure, yes, this is working as we intended and meeting the need that we've set out to do.
If I may very quickly on this point, I completely agree with what Ted said, but I think it's also important to point out that we are sensitive to the needs, especially smaller companies or startups, etc. I think it would be a very good idea if startups, possibly through association mechanism, it's pretty difficult for governments to talk to 5,000 different startups, we usually prefer to channel it with their concerns. And so to encourage startups, possibly through association or trade industry groups, to make sure they are part of that. From our side, we will certainly endeavor to include you in the dialogue, to make sure that your concerns and your needs, which might be slightly different than the needs of a 10,000 employees company, are also taken into account. We have a lot of SMEs in Europe as well. Actually, it's 99% of our industry is made of small and medium enterprises, so we are very sensitive to the needs of small companies.
So two questions from the perspective of a company that is now in the safe harbor, but isn't employing other mechanisms like standard contract clauses to enable this transatlantic flow. First, Andrea, has anything actually changed since February 29th, or are those companies just as vulnerable to the prospect of enforcement by national data protection authorities as they were prior to February 29th, until the draft decision becomes final? And then my question to Ted is, assuming that the draft decision does become final and this all happens, since companies will have to certify to some new principles or additional principles, will there be some grace period or something like that to allow them to do so before they find themselves outside the privacy issue?
To answer your first question, my understanding, which I think is a very solid understanding, is that this is a draft privacy decision, it is not European Union law. Companies cannot use in this moment the draft privacy shield decision as a legal basis to transfer data. They need to use other forms of transfer of personal data. We cannot, on the other hand, this is not the job of the European Commission, we will not take a position whether any data protection authority will decide or not to investigate or enforce. That's up to the national data protection authorities to decide.
Have any of them acted in between those two times, between now and the time period at the end of February?
If any data protection authority has already started enforcement procedures, is that the question?
So the gap between the end of Safe Harbor, that sort of grace period that was given on Safe Harbor, and this, we're in sort of an in-between period, correct?
Yes, because the Article 29 working party said they will not start enforcement procedures until the end of January, if I remember correctly, which might or might not have to do with the fact that we found a political agreement on the 2nd of February, but I will not elaborate on that. Ultimately, this is not, I'm not aware of the Article 29 working party taking positions concerning any kind of moratorium or grace period. You would have to ask the Article 29 working party, it's their responsibility. But again, as I said, as far as I know, at this point in time, companies should not rely on, there is no privacy. So sorry to put it so bluntly, there is a political agreement, but legally speaking, there is no adequacy decision that you can go to privacy shield. It's as simple as that. Hopefully we will have it very soon.
I think the Court of Justice in its ruling did not provide for any grace period, so as of October 2nd, second was the word, 6th?
October,
I can't
it was
remember.
October,
Date.
I remember it was October the 6th.
October 6th. As of October 6th, it was not a valid basis for transfer. European data protection authorities have, through the Article 29 Working Party, which is their committee, come together a number of times and made public statements during this process. I think they have worked to play a very constructive role through what is a clearly uncertain time for businesses. But I think there are also limits on what they can do because they are themselves bound to enforce the law, and the Court of Justice is now ruling what the law is. So that's the limitation we're in now, and candidly is also the limitation we face when we have an adequacy determination, so that it's not for us to provide a grace period because this is really a matter of EU law. What we are doing and have already begun to work on is using this time in the approval process to make sure we're briefing companies as widely as we can so that companies can use this time to understand what the new requirements are. Now, obviously, we understand that companies that have just made investments in model contracts or investments in other instruments of transfer are not going to necessarily want to make new investments in implementing Privacy Shield until they know for certain it will be implemented. But we are trying to make sure that companies know everything they need to know and are ready to move forward. And internally, we're working as quickly as we can to make sure that we're ready so we can handle certifications as quickly as possible.
Okay, I think unfortunately, Tim, we need to end it.
Yeah, no, because I think Tim's been nice to me. I do have 5 minutes.
You do have to go, I'm so sorry.
No,
Okay.
I do have 5 minutes.
Oh, you have 5 minutes?
Yes, we are.
Why don't we do this? Folks that need to go back to work, have other things to do, we'll give 2 minutes for, if you want to pack up, and we'll stay for, take a you stay,
Yeah, so
5
we're
more
on
minutes?
question, yeah.
But we'll just take a little breather, and then we'll do a couple more questions. And then wrap up. Okay. Thank you.
We're not
No, we're gonna do.
we certainly have interest in other companies that would like to certify.
Just very.
Have you seen any, has there been any inordinate issues in privacy during the interim?
I'm just trying to. Okay, thank you all for your patience.
Are you going to start again?
Yeah, we're just gonna do 5 more minutes of last licks. Maybe I wasn't clear on that. And then we'll wrap this up, just make sure we have more questions than I anticipated. Okay? So we're gonna do 5 more minutes, a couple quick questions, and wrap this up. Excellent. I think, did we already have it? Let's, yeah, right here.
Yeah, hi there. I want to clarify, so I just want to make sure that I understand, like, are companies, are U.S. companies now transferring data under the invalidated safe harbor? And if the Privacy Shield either is not formally adopted or struck down, could U.S. companies face retroactive penalties?
On the question whether U.S. companies are right now transferring data under the invalidated safe harbor agreement, you should ask U.S. companies. Sorry, it's an answer only U.S. companies can give. On the second part of your question, I was told this is not an official position of the European Commission because I have not been given a full letter by my colleagues in the legal service, but I was told in internal discussion that technically speaking, the decision of the European Court of Justice of October 2015, which annulled the safe harbor, the decision, technically speaking, the decision is retroactive in terms of its effect, because if annulled the decision, it is as if the decision had never been legally valid. But the consensus that I heard, and again, this is not an official position of the Commission, but the consensus that I heard was that companies which had been transferring their data under a safe harbor regime could be assumed to have been operating in good faith under a law that they believed and everybody believed was actually correct and valid. Now, I'm expressing, I want to be very clear on this, I'm expressing a personal interpretation of the situation. This is not the position of the European Commission, but I think it would be rather risky for companies to start transferring data now under a draft adequacy assessment, the draft privacy shield adequacy assessment, which is yet to receive an opinion that the 29 working party, which is yet to be validated by the member state. And let us be clear that is certainly not what we are expecting as the European Commission, but it's perfectly possible, maybe improbable, but still possible that the Article 31 committee, which I mentioned before, might not approve the draft adequacy decision. We have no signal to be clear that that is going to be the direction, but it is a legal possibility. So companies deciding to try. Honestly, there is not even a legal basis on which it's like as if you were operating under a proposed bill in Congress rather than an actual act signed by the president. You don't do that. Or you do it at your own risk, quite honestly.
Can I actually ask if Mr. Dean could comment about U.S. companies? Is it your understanding that they're transferring data under the invalidated system?
Yeah, listen, I think the reason we felt such great urgency to move forward and reach an agreement after October 6th, the ruling was companies depend on data and the movement of data to conduct very basic business functions, and they need to have a valid legal basis to do that. There are other legal instruments that allow transfers, but they not only take money, but they take time to implement. And it was unrealistic to expect the companies to turn on a dime and do that. And so we thought it was extremely, and I should say that there were potential legal challenges to those other bases for transfer. And so we thought it was very important to move as quickly as we could to a new agreement. I can't speak to what companies did in that time, but I know from hearing directly from firms that they faced a great deal of uncertainty and we're pushing very hard to have us all, come to the table and get to an agreement.
Okay, excellent. Do we have one last question? Okay, thank you both so much. Appreciate it. Thank you all for coming.